I've already told Richard on Twitter how highly I think of the paper. It's so well written, it's so elegantly crafted. He's a gifted writer. So that's it for the positive stuff. My job here is to be critical, and I also, since I'm going to talk about evidence, I have to talk fast because I've got a number of things I've got to get through. In his previous paper, some of the first parts he's already summarized for you. This will be a review. In his previous Yale Law Journal article, Richard distinguished between what he called the internal limits canon, by which he means that the power of Congress is limited by the scope of the enumerated powers, which necessarily means that, quote, there are things Congress cannot do, even without reference to affirmative prohibitions like those in the Bill of Rights, unquote. And he distinguished between that and what he calls the enumeration principle, by which he means the claim that, quote, the federal government is one of the enumerated powers, meaning that it can exercise only those powers affirmatively given to it by the Constitution, unquote. In his previous paper, Richard contended that the enumerated powers principle could be true, and yet these powers would not actually limit the power of Congress. This is because it is logically possible that with the passage of time and changed circumstances, even a circumscribed set of enumerated powers could come to embrace what is, in effect, a national police power. In reply to Richard's article, Kurt Lash rightly denied that any con law scholar had claimed that the internal limits canon is a logically necessary implication of delegated and enumerated powers. Instead, Kurt contends that it is the best reading of the delegated power scheme embodied in our Constitution. Kurt explained how Richard failed to consider how the internal limits canon is essential to the traditional concept of dual sovereignty. And Kurt then explained how it is established by the original public meaning of the text, such as the herein granted language in Article 1 and the 10th Amendment. Whereas Richard would read the 10th Amendment as applying to, quote, the powers not delegated by the Constitution, if any, are reserved to the states respectively or to the people, Kurt correctly explained how it is an implicature of the 10th Amendment that there are powers that are reserved to the states. If so, that is inconsistent with a general power in the national government. If Kurt is right, as I think he is, then whatever may be a logically possible way to read the words of the Constitution in context, and given the substance of the powers that actually were enumerated, it is not the correct way to interpret the original public meaning of the text, which is what originalists care about. Now, in his new paper, Richard does not further pursue the question of the internal limits canon. Instead, he challenges the robustness of the enumerated powers principle. But his claim here is weak in the philosophical sense. He does not deny that the enumerated powers principle is possible, or even the best interpretation of the Constitution. He claims only that it was contested. This then allows him to claim, I suppose, that we are free to reject it today. His aim is not really to reject the enumerated powers principle as a reading of the Constitution, but to deprive it of its historic pedigree among both progressives and conservatives, and among both originalists and non-originalists. Of course, Richard concedes, as he must, that the enumerated powers principle was widely asserted by most, if not every, prominent defender of the Constitution during the ratification debates. For example, it was invoked by James Wilson in Pennsylvania in December of 1787, by James Madison in Virginia in June of 1788, by Alexander Hamilton in New York in July of 1788, and in that same month, in North Carolina, James Iredell described the Constitution as, quote, a great power of attorney under which no power can be exercised but what is expressly given, unquote. And of course, Richard cannot deny that a mere 19 months later, in February of 1790, Madison again asserted this principle in his Bank speech in Congress, an argument that was then picked up and reiterated by Thomas Jefferson as Secretary of State, Edmund Randolph as Attorney General, etc. And he acknowledges that the enumerated powers principle was not repudiated by Alexander Hamilton in his response to this constitutional objection. All of this is in the paper. Now, Richard attempts to undermine all this evidence by intimating that the enumerated powers principle was merely a doctrine of political convenience, perhaps even insincerely asserted by the likes of Wilson, Madison, Hamilton, and Iredell. He suggests that Hamilton had forgotten all about it when he proposed the bank without anticipating this constitutional objection, and it had apparently fallen even from Madison's consciousness when the bank was proposed. Richard's lengthy narrative has at least 5 parts. I think it probably has more than 5 parts, but I could only get myself to get to 5 parts in this 10-minute period. So here they are. Here's the parts I'm going to talk about. First, that the Federalist enumerated powers claims were ultimately unpersuasive in defeating objections to the Constitution, that it lacked a Bill of Rights. Second,
that even Madison privately expressed skepticism about the efficacy of enumerated powers as a constraint on legislative power. Third, that there appear to have been no constitutional objections to the bank in the Senate, and Madison did not even imagine enumerated powers objection to Hamilton's proposal for a national bank until the 11th hour, the words that he just used in his summary, the 11th hour. Fourth, that Madison failed to respond to the charge made by bank supporters that his enumerated powers objection to the bank was inconsistent with his previous advocacy of an implied presidential power of removal. Fifth, that supporters of the bank in the House were surprised by the argument when he made it, and at least some of them, 7 by his count, voiced support for a broader vision of federal power. Now let me go through them. The first of these claims is not quite accurate. It was not the enumerated powers principle that many found unconvincing during the ratification debates. It was the Federalist defense of a constitutional strategy of enumerated powers only to protect the rights retained by the people, as well as the Federalist argument that the external constraints, like a Bill of Rights, would be dangerous because it might imply that all powers not expressly constrained had been granted. But anti-federalists responded that the Constitution already contained external constraints on Congress, so whatever danger might arise from an incomplete enumeration of rights was already being incurred. What anti-federalists demanded and then federalists vowed to provide was a belt and suspenders approach of internal and external and internal constraints on federal power. Second, while Madison may have been skeptical of the effectiveness of holding a legislature to its enumerated powers of internal constraints, he was equally skeptical of the external constraints that would be provided by a Bill of Rights, viewing both as merely parchment barriers. Instead, he favored the structural features of the Constitution as the most important. But we would no more conclude from this that Madison thought that the internal constraints of enumerated powers were not constitutionally binding than we would conclude that Madison thought the external constraints of a Bill of Rights were not constitutionally binding. So what of Richard's claim that, quote, Madison did not answer the charge of interpretive duplicity, unquote, for having advocated an implied power of presidential removal while insisting on holding Congress to its enumerated powers? So he'd done an implied powers thing with respect to presidential powers. Now he's flipping and doing an enumerated powers argument with respect to Congress. I would say that we just don't know if he did or not, if he defended himself from the charge or not. After all, we lack a verbatim transcript of his remarks. When Madison rose to respond to the arguments of the bank supporters, the reporter says that he began by urging that, quote, warmth and passion should be excluded from the discussion, unquote, which may or may not have been an allusion to any impugnment on his character. With respect to the removal power, the reporter merely tells us that, quote, the act vesting in the President of the United States the power of removability has been quoted. Madison recapitulated in a few words his reasons for being in favor of the bill, unquote. What those reasons were and whether they addressed the issue of enumerated powers, the reporter does not say. Richard raises the possibility that no serious constitutional objections appeared to have been raised against the bill in the Senate, although without a written record of its deliberations, this is hard to know, as he concedes. From this, we are to conclude that such arguments were more or less inconceivable until Madison sprung them on a gobsmacked House. If you read the paper, you all got that impression. In his telling, Madison stands alone in presenting his newly minted enumerated powers objection. However, the first constitutional objections to the bank were offered not by Madison, but by James Jackson of Georgia, the day before Madison made his bank speech. The reporter tells us that Jackson, quote, read several passages from the Federalist, unquote. We are not told which ones. And, quote, which he said were directly contrary to the assumptions of power proposed by the bill, unquote. To this, bank supporter John Lawrence of New York responded by citing enumerated powers that justified the bank, suggesting that Jackson had made an enumerated powers internal constraints argument the day before Madison did, and as others did later. Richard contends that the arguments made by 7 defenders of the bank in response to Madison show that, quote, the enumeration principle was a contested proposition among well-informed participants in the constitutional discourse, unquote. I'm just not sure that these speeches support that crucial conclusion. I'm just not convinced the evidence makes out that, even that weak claim. Let's go through it. Elias Boudinot of New Jersey said, quote, "Whatever powers vested heretofore in any individual state, not granted by this instrument, are still in the people of such state and cannot be exercised by Congress. That whatever implication destroys the principle of the Constitution ought to be rejected," unquote. Theodore Sedgwick of Massachusetts said that a legislature, quote, "must assume such auxiliary powers as are necessarily implied in those which are expressly granted," unquote. I'm now talking about the speakers that Richard has cited in support of this contested idea. And then Sedgwick went on to say that whenever, quote, "whenever a power is delegated for express purposes, all the known and usual means for the attainment of the objects expressed are conceded also," unquote. After listing several enumerated powers, Sedgwick contended that, quote, "in the exercise of these powers, the legislature was authorized to exercise all the known and usual means necessary and proper to effectuate the ends which are expressed," unquote. William Smith of South Carolina said, quote, "If the measure, quote, if the measure was not prohibited by any part of the Constitution, an external constraint, was not a violation of the rights of any state or individual, an external constraint, and was peculiarly necessary and proper to carry into operation certain essential powers of the government," unquote, "it was justifiable on the part, it was, quote, justifiable on the part of Congress," unquote, "to enact it." He then said it was, quote, "in the province of the judiciary to annul the law if it should be by them deemed not to result from a fair construction from the," quote, I'm quoting, this is all a quote, "from the powers vested by the Constitution," unquote. Eldridge Gary of Massachusetts said that the only danger that might result from, quote, "upholding a construction of the Constitution which admits of a national bank would be," quote, "the exercise by Congress of a general power to form corporations," unquote, conceding that Congress lacked the general power without explaining why, only that they didn't, assuming that it didn't have a more general power. Jerry also distinguished between, quote, "the powers expressed in the Constitution," unquote, and, quote, "the great and important objects thereof," stating that, quote, "not only in the preamble of the Constitution," I'm sorry, let me just read this. I bollocksed up this quote. Gary also distinguished between the powers expressed in the Constitution and, quote, "the great and important objects thereof stated not only in the preamble of the Constitution, but from our own knowledge of the history of the times that preceded the establishment of it," unquote, which they are included to promote. So he did not view the preamble of a source of power. They were simply the objects that these powers were there to promote. Fisher Ames of Massachusetts stated, quote, "Congress may do what is necessary to the end for which the Constitution was adopted, provided it was not repugnant to the natural rights of man, or to those which have been expressly reserved to themselves, or to the powers which are assigned to the states," unquote. But then this is followed immediately with this, quote, "By that instrument, certain powers are specially delegated. By that instrument, certain powers are specially delegated together with all powers necessary and proper to carry them into execution," unquote. So this appears to be arguing that the enumerated and implied powers must be construed consistently with the end for which the Constitution was adopted, unquote. Richard Rice, John Lawrence of New York, considered the permissibility of incorporating the bank established by the fact that no constitutional provision forbade the action. The question of an enumerated power just didn't come up, unquote. Yet, while Lawrence does seem to be arguing based on the preamble, I think that's right, he also relies on the enumerated power, quote, "power to dispose of certain property on lands and to make all useful rules and regulations for its purpose." And earlier, the day before Madison spoke, in response to Jackson's speech, Lawrence asserted that, quote, "the government of the United States is vested by the Constitution with the power of borrowing money, and in pursuance of this idea, they have a right to create capital by which they may, with greater facility, carry the powers of borrowing on any emergency into effect." So he did offer an enumerated powers argument in defense of the bank. Finally, the one guy who does generally fit the description that Richard attributes to all seven, John Vining of Delaware, did say that when it became, quote, "a free and independent nation," unquote, pursuant to the Declaration of Independence, the United States, quote, "derived all the powers appertaining to a nation." That's pretty broad, which includes the power, he said, to make corporations. That was all done in a single sentence He did not discuss enumerated powers. Unlike the others, he did not discuss enumerated powers. His speech was really about other matters, but he did have that one sentence about the Declaration. Rather than challenge the doctrine of enumerated powers, I think, my reading of the debate, supporters of the bank largely contested the proposition that Congress was limited to expressly enumerated powers. I don't have the time to provide all the quotes of that. But since Madison had already affirmed in his speech that Congress could exercise implied powers that were incident to the expressly enumerated ones, they were attacking a straw man. No one was arguing that Congress lacked implied powers. No one that I read. They were contesting whether an implied power to incorporate a bank was fairly incident to the expressly delegated power. While Richard's narrative makes it appear that only Madison asserted the enumerated powers theory, he was joined in this by Jackson, who I mentioned raised it before Madison did, and by Michael Stone of Maryland and William Giles of Virginia. Stone condemned reliance on the preamble, which is interestingly several congressmen referred to as context, which is one of the important things I learned from rereading the bank speeches after 20 years of not having read them. I'll say more about that later. Stone condemned reliance on the preamble, which he called context, as the source of legislative power, asking, quote, "Is there any power under heaven which could not be exercised with the extensive limits of this preamble?" Giles charged that, quote, "If this reasoning were to be conclusive, every object of government would be within the authority of Congress, and the detail of the Constitution would have been wholly unnecessary, farther than to designate the several branches of the government which were to be entrusted with this unlimited discretionary choice of means to produce these specified ends," unquote. So along with Boudinot, Stone and Giles seem to be invoking the internal limits canon, as well as the enumerated powers principle. I'm almost done. Richard summarizes this claim as follows. He summarizes his thesis as follows, quote, "The point of noticing their various ways of rejecting Madison's enumerated powers framework is not to suggest that their approaches reflected an objective meaning of the Constitution from which Madison had strayed. It is to show that at the time of the first Congress, the enumeration principle was a contested proposition among well-informed participants in constitutional discourse. Their views do not demonstrate that Madison was mistaken about the Constitution, and Madison's views do not demonstrate that his opponents were mistaken about the Constitution either," unquote. After having reviewed the materials, thanks to the stimulation of Richard's great paper, I just don't think that the bank debates bear out this philosophically weak claim. As Richard notes, these are not verbatim reports of speeches, and we must be cautious when focusing on particular wording. But I found no one who expressly rejected enumerated powers. Most of the bank supporters argued that the bank was within the enumerated powers of Congress to enact, though they were all over the map on exactly which power or set of powers the bank was necessary and proper to execute. When the preamble was invoked, it was generally to provide what they called context. And what I learned from this is they use context, the term, the word context, as a synonym for the preamble, sometimes just referring to it as context, meaning the preamble, on how the enumerated powers they were using context to claim that the enumerated powers should be liberally construed. I thank Richard for this opportunity to reread the bank debate in the House. I found much more there that I had forgotten about or hadn't noticed when I read them close to 20 years ago, like the treatment of the preamble as context and statements affirming judicial review and rejecting deference. But these debates do not establish even the weak claim that the enumerated powers principle was contested. And they certainly don't support a conclusion that that this is the best reading of the text of the Constitution, which in the end is what matters.
It's not my claim, and if the paper reads this way, I need to correct it, that Madison is the only person who articulates opposition to the bank in enumerated powers terms, or even that he's the first, because Jackson does say it first in the record. My claim is that until very shortly before, 3 days before, Madison speaks, I can't find any record of anyone's having articulated that argument. I agree also that we can disagree about the readings of the particular text, but some number of the representatives I focus on also make enumerated powers arguments, right? I think of these as belt and suspenders arguments. That is to say, it's not that they disavow that mode of argument. I very much agree about the point about incomplete records, right? It's a hazard of this kind of investigation more generally. Oh, and on the remark that I make about Lawrence, you're right. I need to strike that remark because of the thing that he says elsewhere. Thank you. I'll just say this to stop. Randy characterizes my claim as philosophically weak. I'd like to characterize it just as modest. There are, so, I mean, on the large, like, I have a reading of the vesting clause and of the 10th Amendment that I think makes sense. We're not going to rehearse the whole thing here. I would characterize the claim as modest, but still worth making, and worth knowing about and reckoning with. And I'll stop.